Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss one another important case, that is Bachan Singh versus State of Punjab, the rarest of the rare doctrine.
Today, we're diving into a landmark case that truly set a turning point in Indian legal history. Bachan Singh versus the State of Punjab. Look, if you're preparing for the judiciary or the UPSC, you just can't afford to miss this judgment. Why? Because this single case completely changed the laws around capital punishment in India. I mean, it fundamentally reshaped the entire philosophy of punishment in our country. So, let's get right into it. All right, first things first, let's get a quick snapshot of the case. In this section, we'll cover the foundational facts, the stuff that will give you a solid base to understand the deeper legal reasoning. For your exam revision, getting these basics absolutely clear is key. So the case is Bachan Singh versus the State of Punjab. Now, something you should immediately notice here is that it was decided by a 5-judge constitutional bench of the Supreme Court. That right there tells you just how constitutionally important this was. And the judgment date? May 9th, 1980. You'll want to remember that date. It marks a truly pivotal moment in Indian law. On one side, you have the appellant, Bachan Singh. He had been sentenced to death for the murder of 3 people. And on the other side, you have the respondent, the state of Punjab, which was defending the legality of that death sentence. You see, this wasn't just a simple criminal appeal. It was a showdown between an individual and the state over the ultimate question of life and death. So, how did this all start? Well, the journey began with Bachan Singh's conviction. The Sessions Court gave him the death sentence, which was then confirmed by the High Court. But, and this is the crucial part, when the case reached the Supreme Court, its whole scope changed. The challenge is no longer just about Bachan Singh's specific sentence. It became a direct challenge to the constitutional validity of the death penalty itself. Okay, now we get to the very heart of the case, the core constitutional questions. The answers to these questions gave Indian law a completely new direction. And believe me, these are the concepts that get tested again and again in exams. So you'll want to pay very close attention here. So the first and most fundamental question was this: is Section 302 of the Indian Penal Code, the part that prescribes the death penalty for murder, actually constitutionally valid? I mean, think about it. Does the state even have the right, within our constitutional framework, to take a citizen's life? And then there was a second, equally crucial question. This one related to the sentencing procedure itself. The court had to ask, is Section 354.3 of the Criminal Procedure Code arbitrary? The section that gives judges the power to choose between life imprisonment and a death sentence. Was this provision giving judges unlimited, unguided power without any clear guidelines? All right, let's dive into the arguments presented by both sides in court. This was a classic legal debate, really, where fundamental rights were clashing head-on with the state's power to punish. It was a genuine clash of constitutional philosophies. Okay, so what we see here is a fundamental clash of ideas. The petitioner's side argued that the death penalty violates Articles 14, 19, and 21, what we call the Golden Triangle of Rights. Their whole point was that its imposition is arbitrary and depends way too much on the individual judge. In response, the state pointed out that Article 21 itself allows for the deprivation of life through a procedure established by law. Plus, they noted that the Constitution even mentions the death penalty in the context of pardon powers for the president and governors, which kind of implies the Constitution acknowledges its existence. So, with all these complex and competing arguments on the table, how in the world did the Supreme Court solve this constitutional puzzle? Let's break down the court's deep and meticulous reasoning, which is really a masterclass in constitutional balancing. The court's logic was remarkably clear. First step, they dismissed the challenge under Article 19, basically saying that committing a crime like murder isn't a protected fundamental freedom. Okay, fair enough. Step 2, the focus shifted to Article 21. The court agreed, yes, life can be taken by law, but, and this is huge, they built on the Maneka Gandhi precedent and said that procedure has to be fair, just, and reasonable. Step 3, then the court looked at the new CRPC's Section 354.3 and saw it as a critical safeguard because it forces judges to give special reasons for a death sentence. And finally, Step 4, this is the monumental shift. With all that in place, life imprisonment became the rule, and the death penalty became the exception. This completely flipped the previous legal position on its head. And it was from this exact line of reasoning that a doctrine was born. A doctrine that would forever change the Indian criminal justice system. The rarest of the rare doctrine. Right? This single line pretty much summarizes the entire judgment. This is the essence of it. The court said that the death penalty should only be given in the rarest of rare cases and only when the alternative option of life imprisonment is unquestionably foreclosed. In other words, only when life in prison just seems completely inadequate to serve justice. So, what exactly is this rarest of the rare doctrine? Well, it's a principle that reserves the death penalty for only the most exceptional and heinous cases. And to figure that out, the court has to do a balancing act. It has to weigh the aggravating circumstances of the crime, things like its brutality, against the mitigating circumstances of the criminal, like their background, age, or potential for reform. So the final verdict was this. The death penalty as a provision is constitutionally valid. It wasn't struck down. But its application was severely restricted by this new, very strict guideline of the rarest of the rare doctrine. So it wasn't abolished, but you could say it was constitutionalized under some really strict conditions. Now, for all you law students out there, this is an absolutely crucial point. The ratio decidendi of this case, that's the binding principle, is the rarest of the rare doctrine itself. Any general discussions the court had about penology or the science of punishment, that's all considered obiter dicta. It's persuasive, sure, but not legally binding on lower courts. Okay, so now that we've got a handle on the judgment and its reasoning, let's pull everything together by looking at its long-term impact. And after that, we'll do a super quick recap to make sure all these key points are locked in for your exams. The impact of the Bachan Singh judgment was, well, profound. It made life imprisonment the default sentence for murder. It established a structured framework for sentencing based on those aggravating versus mitigating factors. It reigned in the arbitrary discretion of judges in capital cases, and it became the guiding precedent for every single death penalty case that followed in India. All right, it's time for our 1-minute smart revision. Let's lock in the 5 key takeaways. Number 1, the death penalty is constitutionally valid. 2, but its application is limited by the rarest of the rare doctrine. 3, life imprisonment is the rule, the death penalty is the exception. 4, the sentence must balance aggravating and mitigating circumstances. And number 5, the procedure under Article 21 must be fair, just, and reasonable. Got it? That's the whole case in a nutshell. You know, the Bachan Singh case is perfect proof that the law isn't static. It evolves with our societal values. And this judgment continues to fuel the debate on capital punishment even today. For more detailed, exam-focused legal analysis just like this, make sure you follow us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.
This is Ganga Education. Subscribe for more legal content. Thank you.